Justin?
Yes, Representative Morris.
Hello, I'm in.
Hello, I'm going to put you in your breakout room.
Okay,
And yeah, when they come out, we are live, just so you know. Okay.
okay, thanks.
Yeah.
I'm slowly seeing people come back. For those who are tuning in, we have just finished some of our caucuses. We're waiting on our colleagues to join us for work sessions. You'll see many of us keeping our video off until we're all assembled. And then we will jump in.
Got it. Yeah.
Added me to a breakout room again. Have they?
We are indeed here.
Yeah, we're done.
Breakout room?
Yep, I think we are in the main session, or we are in the session.
Yes.
Oh, we're back. Okay. I'm not spying on you this time.
We've all found our way through the right, parts of the rabbit holes.
Okay.
And I think we've got everyone. So with that, I'm going to welcome back everyone to the Committee on Labor and Housing. Thank you for your patience on our long day. We still have one bill in front of us. I'm going to open the work session on LD 1889, an act to amend the Whistleblowers Protection Act to ensure coverage in unionized workplaces. It was Representative Tom Harnett's bill, and I'm going to kick it over to Steve to give us a review and jot our memories.
Sure. So this bill changes the Whistleblowers Protection Act in order to clarify its scope. It repeals a section of the Whistleblowers Protection Act that was interpreted by the Maine Supreme Judicial Court in the case of Netto v. Twin Rivers Company, LLC, as a bar to enforcement of the act in many cases in which a collective bargaining agreement is in place. So I included sort of the statutory section that would be repealed. I do have some background that was taken directly from Maine Human Rights Commission counsel, Barbara Archer Hirsch. So the legislature enacted the Whistleblowers Protection Act in 1983 to prevent discrimination by an employer of an employee who reports that the employer is violating a law or a rule of the state, puts risks of health or safety of employee or others at risk, etc. The text proposed being repealed in this bill has been in effect since the enactment of the Whistleblowers Protection Act. Federal law has provided since 1947 that federal courts have jurisdiction over contract disputes between employers and labor organizations, and that's in 29 USC section 185A, but it's known as section 301. Since then, the United States Supreme Court has issued multiple decisions finding that these so-called section 301 implies that there's a preemptive federal labor law. So this would ensure that collective bargaining agreements or CBAs would be interpreted uniformly throughout the US and maintain uniformity in interstate commerce. The Maine Human Rights Commission has enforced the Whistleblowers Protection Act since 1987 and has consistently interpreted the Whistleblowers Protection Act to apply to all employees and employers, regardless of whether there is a collective bargaining agreement in place. So a little bit of background in the case that sort of spurred this legislation. Bernard Netto was an employee at Twin Rivers Paper Company and a member of the union, and his workplace was governed by a collective bargaining agreement. Mr. Netto made a safety-related complaint in February of 2015, but in November of 2015, he himself also committed a safety violation that was grounds for discharge. He was then placed on a so-called last chance agreement in accordance with the collective bargaining agreement policy. And this provided that he would be discharged after any additional violation of work rules. So after this, he continued to complain about workplace safety issues. And in August 2016, he failed to report a workplace accident and was subsequently discharged. So he filed a claim with the Maine Human Rights Commission alleging Whistleblower Protection Act retaliation. He requested a right to sue letter, and in September of 2018, he filed suit in Superior Court. The Superior Court granted judgment in Twin Rivers' favor, stating that the court could not determine whether enforcing the Whistleblowers Protection Act would diminish collective bargaining agreement rights pursuant to the above language, that's the subject of this bill, without interpreting the collective bargaining agreement itself, in that section 301 preemption precluded the state court from such interpretation. The law court noted that this section of law that's the subject of this bill required that in any Whistleblower Protection Act claim that the collective bargaining agreement must be examined to ensure the dispute would not diminish or impair the rights of an employee, an employer, or a union. This holding, as noted in testimony, is consistent with federal court decisions over Maine's federal courts, federal court decisions from Maine's federal courts. The law court did not say that all Whistleblower Protection Act claims made by employees in unionized workplaces are preempted, but they found specifically that Mr. Netto's claims were clearly due to the facts of the case. Mr. Netto claimed that Twin Rivers violated the collective bargaining agreement in imposing the last chance agreement. So the law court found his claim required interpretation of the collective bargaining agreement. The law court in its ruling provided one example of a Whistleblower Protection Act claim that might not be preempted, by the court. And in that case, the plaintiff and whistleblower had already prevailed in arbitration under the collective bargaining agreement. So the parties' collective bargaining agreement was not the issue. So in summation, the law court found that language in LD 1889 can require the court to interpret the language of the collective bargaining agreement, which conflicts with federal law, which states that federal courts have this jurisdiction. So the language before you today that's scheduled for repeal may be preempted by federal law. We have not yet received a preliminary fiscal impact statement. And I believe that Ms. Sneerson and Barbara Arsher-Hirsch from the Maine Human Rights Commission are here to answer any legal questions. I am not an attorney, and I'm not fortunate enough to play one on TV. So
Only on YouTube, right? With that, I don't know if we want to jump in, if we have any questions for Ms. Hirscher or Ms. Sneerson, or if there's where we want to start. And I have to say thank you for your patience, Ms. Hirscher and Ms. Sneerson, for our late start date. And thank you, Steve, for that thorough overview. Whew, should have had that third cup of coffee. With that, Representative Sylvester has a question, so I'll let him kick it off.
Thank you, Madam Chair. And this is for either one of you that wants to jump in. This happens a lot in labor law, where a particular case with a particular set of facts gets determined one way or another, and people sort of take it as a broad ruling of law in general. And so my question for you is if you could sort of parse between those two things. Do you believe that this ruling is really particular to this case and brings up the possibility of there being a problem with between state and federal law, or do you think that the language of the bill fixes that problem? And why don't I start with you, Ms. Hirsch?
I was gonna say, I'm going to guess that Amy wants me to take the tough legal stuff. Look, she's nodding her head. So, I mean, I think the answer is both. I certainly agree, and I apologize. I was late getting here, so I didn't hear all of Mr. Langland's presentation. But I do think that the law court made some effort to limit the case to the specifics of Mr. Neto's case, but there's also broad language in there. The language in the footnote about the Galouche case, if those are the only WPA claims for union cases, I think that's a problem for us. I do think that having the position so that more of our cases are preempted than would normally be under the Labor Management Relations Act, I think it is a problem, in part because of our work sharing agreements with federal agencies. So some claims, granted, they don't cover our whistleblower claims, but I think there's a potential for a conflict there. And I can tell you from experience that people coming to the commission are concerned about this. It gets raised as a defense that there's a collective bargaining agreement, so we don't have jurisdiction, which is, we've had a bunch of WPA claims on hold for the past several months while we try to figure out which ones are preempted and which ones aren't. And parsing that is very time consuming and would be unnecessary should you move this bill forward and it pass.
Thank you. That's very helpful.
Up next, I have a question from Representative Drinkwater and then Representative Bradstreet.
Thank you, Madam Chair. A question for Ms. Hirsch here. This overhaul, whatever we're doing here, is really a question of law. To change the law, don't change the law. I'm curious as to why this bill came to the Labor Committee when this really should have gone to judicial.
I wish I knew the answer to that. The commission's bills usually do go to judiciary, but they sent us here and here we are. we consider it a field trip. We're happy to be here, but I don't know why.
Well, I personally would have felt a lot more comfortable had the Attorney General come in and given his an opinion on this. A question again for you is, you said in your testimony that a recent decision, what's your interpretation of recent? 2 years, 1 year?
Well, this happened during the last legislative session. So this is the first time that we knew about it to address it. So what my definition of recent is, I guess, depends on what I'm talking about. But certainly this case is maybe a year old, I think. And the impacts of it are new, and that's what we're concerned about.
Well, when I read the case, it says that it was 2019. So I was just, to me, that didn't strike me as recent. And then when I read the case, it's actually talking about preemption has been the law since 1987. So it just confuses somebody, that doesn't know a whole lot about legal. So thank you.
I'll tell you, the incidents in the underlying case happened in 2019, but the decision from the law court was from early 2021. So that was not that long ago. I've already forgotten what the second half of what I was going to respond to was. I'm so sorry. We had our commission meeting today. It's been a long day and I'm a little spacey.
All in the same boat. I don't know, Representative Drinkwater, would you care to rephrase the second part of your question?
What's for dinner? No.
Perfect.
I'm just curious as why it came to labor and not judicial. And I would have liked to see an Attorney General Fry come in and weigh in on this.
Well,
so that's
if
my
I could-
whole point.
And I will just, my name's Amy Sneerson, I'm the executive director, and Barbara is our commission's lawyer, but I would just say what I think she would say, which is that the Attorney General the Office of the Attorney General has no jurisdiction whatsoever. We're an independent state agency, and by statute, we are given the duty to interpret and enforce the Whistleblowers Protection Act.
That's actually a really important clarification that I knew it was a separate entity, but I did not realize that legally it doesn't necessarily fall underneath the AG. So today I learned something new.
There you go.
And as far as the referencing about where the bill goes, Representative Drinkwater, I mean, that is something that, we can discuss if we want, the Judiciary Committee to weigh in on the matter. This happens all the time in other committees. And it's something that we can inquire about too. It's always, that tricky matter where you have something that might be in one chapter or dealing with one part of here. And, this very clearly, tucks into what goes into the Judiciary Committee. And since it deals with collective bargaining, also sort of pulls in our wheelhouse. So that's just, something we can consider as a committee if we want to ask that of that jurisdiction. With that, Representative Bradstreet.
Thank you, Madam Chair. One thing quickly, I noticed the sponsor isn't here. I'm assuming we have leave to talk about this in his absence. And secondly, I do notice that we have Mr. Dan Riley with us today, and I know he's an attorney, and I hate to put him on the spot, but I wonder if he might have some information on this that would be useful to us.
Generally, did you have a specific question for him, Representative Bradstreet? Because generally we have folks from the department come up and, if we have a specific area of knowledge, so if you had a specific question, or we don't want to have everybody testify again.
If he's satisfied that the analyst interpretation is that the federal government, federal courts do normally have jurisdiction over matters such as this. I wonder if he'd be in acquiescence for that.
Representative Bradstreet, I apologize. My internet just went unstable and I got the warning and I did not hear everything that was said from both you and I think I heard Representative Sylvester. I did hear you asking about the bill sponsor. I did want to share that we checked in with him to see if he could make the work session. And he is unfortunately tied up in his committee and gave us his permission to go ahead.
Very good.
What was the second part of your question? Was it that or did that?
I noticed we have Mr. Dan Riley with us today, and I wonder if he would give us his interpretation as to whether or not federal courts do indeed have jurisdiction over such matters that we're talking about today, if he agrees with the interpretation of the law court.
Okay. Mr. Riley, are you able to answer that question? If everyone can still hear me. Can everyone still hear me? Okay.
Senator Daughtry.
Can hear you.
Yeah,
We
this is
can
Dan.
see you.
This is Dan Riley. I'm simply monitoring this work session for a client. I'm not prepared to respond to Representative Bradstreet's question. I do appreciate it, but I don't think I can provide you with a proper answer under these circumstances.
Thank you. I thought I would ask while you were there.
Absolutely. Thank you for your honesty and for that clarification. That Representative Sylvester?
Thanks. The piece that you missed, Senator, is generally in this committee, we only allow folks from the departments, folks who have specific knowledge, sponsors to come through. And for advocates, generally, if they have information that they want to bring forward, they bring it through either through one of us or beforehand. And so we don't generally just ask folks to retestify about whether or not, the analyst's interpretation was correct, et cetera. So I just wanted to, that was what I had said, that you missed. And, because it just makes a very long day to have everybody retestify in the work session. So we can talk about that more as a committee later.
Absolutely. And just, as a work session, coming from obviously another committee and still learning the ropes of this one as well. If someone needs clarification or more information, that is absolutely, of course, welcome. And, making sure we're able to get those sources in front of us. But, as far as Mr. Langland's analysis, I think that's a separate thing. And I think, Mr. Langland's done an excellent job of getting us all the information that's before us to help us be able to navigate these waters as well. Do I have any other questions from the committee? We're never going to be able to answer Representative Drinkwater's question about what's for dinner if people don't start speaking up. Representative Sylvester, followed by Senator Hickman.
In that case, I would, Steve, is this amended or are we still at the original bill?
Original bill.
Then I would move ought to pass.
We have a motion of ought to pass from Representative Sylvester. Do I have a second? It is seconded by Representative Rader. We have a motion of ought to pass on the floor. Moving on to discussion, Senator Hickman.
I was on mute. I was making a motion to pass the bill, but it's been done. Thank you.
Sounds good. Do I have any questions, thoughts, feelings, clarification?
Go
right ahead.
I trust the analyst's analysis. I trust the commission counsel. I'm supporting the bill.
Wonderful. Thank you, Senator Hickman. And I will add a ditto, and I'm grateful for the commission to be here to answer any questions and especially to learn about the separate jurisdictions. So thank you for that. Representative Drinkwater.
Thank you, Madam Chair. We won't prolong this because I know we all got other things to do. The analysis goes on to say in short that this bill may be preempted by federal law, but he is not an attorney, as he stated, and therefore this will have to play itself out.
Duly noted, Representative Drinkwater. Any other comments, thoughts, feelings, questions, songs, ditties? Okay, I think the ship is definitely sailing. With that, Justin, we have a motion on the floor. Could you please call the roll?
Senator Daughtry.
Yay.
Senator Daughtry, yay. Senator Guerin.
No.
Senator Guerin, no. Senator Hickman.
Yay.
Senator Hickman, yay. Representative Sylvester.
Yay.
Representative Sylvester, yay. Representative Bradstreet.
No.
Representative Bradstreet, no. Representative Cuddy. Representative Cuddy is absent. Representative Drinkwater.
No.
Representative Drinkwater, no. Representative Gear.
Yes.
Representative Gears, yes. Representative Morris.
No.
Representative Morris is no. Representative Pepworth.
Yes.
Representative Pepworth is yes. Representative Prescott.
No.
Representative Prescott is no. Representative Rader.
Yes.
Representative Rader is yes. Representative Warren.
Yes.
Representative Warren is yes. So we have 7 ought to pass, 5 not. Oh, well, I don't know what the minority is, if they want to say that.
Do we have a report?
Ought not to pass.
Okay.
Okay.
And
And
one
that-
absent.
7 to 5, correct, Justin?
That's correct. One absent.
Perfect. With that, the ought to pass motion carries. Any further questions or thoughts before we close this work session? Representative Prescott?
Yeah, hey, what's it like to be the majority?
I
just want to win one. Come on.
Representative Prescott, I will actually offer, if the committee will indulge me 10 seconds, a personal anecdote of having been in, I like to call the purple when not everyone was in a majority. And I can tell you, I have actually gotten things through when you don't have the majority. Takes a lot of hard work and due diligence. But kidding aside, I'm going to close the work session on LD 1889. I want to thank everyone who's here for this bill and from the commission as well. And I especially want to thank all of the committee members for their hard work and patience today. I know it was a slog. And with that, hopefully see some of you in person on Wednesday. And happy Valentine's Day. I hope everyone gets some time with their Valentine tonight.